In a civil lawsuit in New York, if the defense refuses to honor a scheduling order by the judge, are there any repercussions? Are there any fines? Are there any sanctions? You want to know the answer? Come join me as I share with you this great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney practicing law here in the state of New York. The answer is maybe and maybe. Here's what I mean. When you start a lawsuit for an accident matter or a medical malpractice matter or even a wrongful death matter, within a few months the court calls the attorneys into court to have what's known as a scheduling conference. We call that a preliminary conference. And now the attorneys agree amongst themselves about when things are going to happen during the course of the lawsuit. When is the injured victim going to be asked questions for pretrial testimony? When are the people who are being sued going to be questioned? When does each side have to give each other various documents known as discovery? So all of those dates and time frames get put into this document known as a scheduling order. And then we hand it to the court, the judge signs it, and now it becomes an official order. What happens though if the defense doesn't honor those particular time frames? Can they get fined? Can they get sanctioned? The answer is maybe, but it takes a lot to go ahead and get that done. Let's say the order says the doctor has to be produced for his pretrial testimony by January 1st. And let's say it's now October 30th. Every week I'm on the phone with the defense attorney's office saying, when are you producing your doctor for his pretrial testimony? And I'll get excuses. Oh, the doctor's not available. We're trying to get dates. We'll let you know. Well, week after week goes by and they don't let us know. So now we're getting closer and I call and I say, listen, the doctor has to be produced. When are you producing him? Oh, we need an extra few weeks. Okay. How much time do you need? Oh, we need 2 weeks. Fine. Now, as long as the attorneys can agree on the time frame, there's no problem. But what happens if the 2 weeks go by and they still have not produced their doctor? Well, now I may have to ask the court to intervene. And typically, when we ask the judge to intervene, we have to do it in formal written papers. But the judge doesn't want to get bogged down with all those formal written papers. Instead, they call the attorneys into court, and now the judge or the judge's law secretary will turn around and say, what's the problem here? Why haven't you produced your doctor as indicated by this court order? And now the defense attorney is going to give them some sort of excuse. And based upon that answer, he's now going to either direct them and compel them to show up at a particular time and day, or he now could go ahead and do something more drastic. Listen, if you don't produce your doctor by this date, we're going to strike your answer, which is devastating. But it doesn't really come to that. So why do I share this video with you? I share this information with you just to give you an insight and an understanding into what goes on in these civil lawsuits here in New York. You know, I realize you're watching this video because you have questions or concerns about your own particular matter. Well, if your matter did happen here in New York and you're thinking about bringing a lawsuit, but you have questions that need answers first, what I invite you to do is pick up the phone and call me. I can answer your legal questions. You know, this is something I do every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.